Farm Owners Association of America encourages everyone to watch the full-length version of our context training presentation, but many small business owners are simply too busy to watch it in one viewing. So Team POAA is also making context available in 5 short episodes as a convenience to anyone who wants to learn some basic business law principles by exploring the context of our association's objections to a proposed settlement of 3 employment misclassification class actions. To be clear, if you're a current owner operating in California, Illinois, or Massachusetts, whether or not you want to opt in, opt out, or object to the proposed class settlement is a decision for you and for you alone. If you operate your business in any of the other 47 states, you may want to consider hiring an attorney or joining POAA and seeking permission from the court to intervene and object to the proposed class settlement for reasons we addressed throughout the presentation. Please, we encourage everyone to watch all 5 episodes. The board simply does not believe that Pepperidge Farm wants to buy back all existing businesses in California, Illinois, and Massachusetts to better protect current owners. We believe that there are also substantial new rights that Pepperidge Farm is trying to gain for itself through the proposed class settlement process. But we're jumping ahead. In fairness, we want to compare how the lawyers in the class action case characterized the proposed new contract versus how the board characterizes the proposed new contract. And to do that, we should bear in mind that wisdom begins with the definition of terms, and it's time for us to really wise up and start defining a lot of terms. And the first term we're going to define is characterization. It means a description of the distinctive nature or the main features of something or someone. The unopposed motion and memorandum of law filed with the court present class counsel's and Pepperidge Farm's arguments in favor of the new revised contracts. The lawyers characterized the substantial amendments and the numerous material changes to the existing consignment contracts as merely revised contract agreement, rather than calling it for what it is, which is a radically new form of contractual relationship with Pepperidge Farm. If you take a look at the definition of revised, it means to make alterations to something written or printed, to reconsider, to re-examine, to amend. To revise is to make alterations. Alterations is defined as change or cause to change in character or composition, typically in a comparatively small but significant way. And we know that altering even one character of the consignment contract can radically change the character of the deal. Indeed, the revised consignment agreement that's being required to settle the wage-related claims will cause significant changes to the existing contractual relationships between Pepperidge Farm and current distributors because there are so many numerous and substantial alterations that result in a radically new form of consignment contract. Why does the board believe that? Well, because that's exactly what the unopposed motion seeking preliminary approval of the proposed class settlement says. The following slides are actually copied and pasted directly from the unopposed motion. But before we get into the specific list of the main features, before we get into the characterization of the new contract by class counsel and Pepperidge Farm, you need to know that it raised red flags for the board to read that the addition and subtraction of numerous contractual provisions only grant new rights to the distributors without any characterization of new rights being granted to Pepperidge Farm. So we're going to need to determine for ourselves whether or not the proposed new contract really just provides extra protections from Pepperidge Farm's undue control over current distributors, or whether the proposed new contract also grants Pepperidge Farm substantial new rights. And I think you'll be surprised to know that it does. If we take a look at the first bullet point, a provision requiring Pepperidge Farm to provide current distributors with advance notice of any product it wishes to allocate to current distributors beyond what they've ordered. Well, that's a new right for Pepperidge Farm. Under the existing consignment contracts, paragraph 2, under the existing consignment contracts, Pepperidge Farm only can allocate product when demand exceeds its production capacity. It has no right to allocate any product it wishes to allocate beyond what distributors have ordered. Some of you are probably thinking that the board's making a mountain out of a molehill with this first bullet point from the motion. You're probably thinking, well, so what? Pepperidge Farm's been direct shipping pallets and allocating product as much as it wishes for years now. Why not just give them the right in the new contract? Because at least now we'll have the right to notice before they do it. And if you actually read the proposed new contract, current distributors will have the right to object when Pepperidge Farm wants to allocate product. But the board believes that those rights to notice and objection are illusory because the objections go to Pepperidge Farm. And you're asking Pepperidge Farm to reconsider and determine whether or not its first exercise of business judgment was commercially unreasonable. Is that good enough? Well, what is commercially unreasonable? Is it defined in the contract? No. And there's the rub. If Pepperidge Farm overrules your objection and just sends as much product of any product that it wishes, then what do you do? Well, we'll get into that in a minute. But first, let's take a quick look at some of the other bullet points that we copied and pasted from the motion. Express clarification that Pepperidge Farm's recommended best practices for service frequency are not a contractual obligation. Clarification that current owners have discretion to accept or reject a variety of recommendations from Pepperidge Farm. Quite frankly, the board doesn't see a need for a radically new form of contract to clarify those current rights under the existing contract. Current owners always had the right to negotiate planograms directly with local stores. Do we really need to replace the existing forms of business with the new form of business just to get a provision that expressly prohibits Pepperidge Farm from approving or disapproving the people we hire to help work our business? The board doesn't think so because under the existing contracts, you have the right to hire helpers so long as they comport themselves with the high reputation of the bakery. Well, what about the significant new rights for current distributors who wish to sell their territories? Define significant. Sufficiently great or important to be worthy of attention, noteworthy. And if we give a little extra attention to the existing right to sell territories, you're going to find that the new proposed right to sell isn't more valuable than the rights you already have under the yellow and the green. The claim that they're significant new rights implies that they're new and improved, better, more valuable. And in reality, they're just substantially different than the existing rights. The next bullet point raised red flags for the board, and it should for you too, because the language used is meaningless. Elimination of certain language that potentially authorized Pepperidge Farm to terminate its agreement with the current distributor. What language? Certain language? If it was certain, then why is it only a potentiality? Let's define potential. Potentially, with the capacity to develop or happen in the future. Well, a little more than a year ago, we were forced to recall potentially poisonous product that Pepperidge Farm released to us for distribution in the marketplace. We couldn't generate a penny of new revenue during the scramble to protect consumers and the Pepperidge Farm brand, but our burn rates skyrocketed while our sales commissions ground to a halt. Out of an understandable abundance of caution, accounts demanded that we recall every SKU, not just the tainted SKU. So we shouldered the extra carrying cost of the non-recalled fresh product, and we at least doubled our cost to serve by rotating the untainted fresh product back into accounts over the ensuing weeks. And then adding insult to injury, Pepperidge Farm still automatically assessed thousands of dollars in chargebacks for allegedly excessive amounts of stale returns during that quarter, as though it was business as usual. Although Pepperidge Farm undoubtedly suffered some short-term financial losses in connection with the recall, it will likely recoup all of those financial losses from the supplier, and we will not. So the next bulletin point about a 2% commission on the recalled product, is that good enough? Board doesn't think so. Quite frankly, the next bullet point seems meaningless too. A provision allowing current distributors to seek financial relief from Pepperidge Farm when its product is damaged through no fault of their own. So what? You have the right to seek financial relief from Pepperidge Farm under the existing contracts. In fact, the new OSD, overage, shortages, and damage procedure, allows you to get financial relief when the product arrives damaged through no fault of your own. And if you need to seek financial relief because of a problem account with a lot of damage, you already have the right to do it. We don't need a brand new form of contract and a brand new form of contractual relationship to be able to seek financial relief. There's no guarantee that they're going to let you find it. Which brings us to the last bullet point, the last item in the list of main features, the last characterization in the unopposed motion from class counsel and Pepperidge Farm about the new form of business relationship. And the last item is a new alternative dispute resolution process, including mandatory arbitration. Well, the proposed new contracts present several pages of convoluted terms and conditions for mandatory arbitration. If the number of pages devoted to defining contractual rights and responsibilities is any indication of its importance, then mandatory arbitration must be extremely important to Pepperidge Farm because its complex provisions are as long, if not longer, than the entire existing contracts. And the provisions incorporate by reference volumes of additional rules and regulations applicable to arbitration proceedings under the for-profit rules of JAMS. It's important for everyone to know, current owners to know, that there's absolutely nothing in the existing contracts that prohibits the parties from voluntarily agreeing to voluntary arbitration. Given that Pepperidge Farm is apparently so keen on arbitration, all they need to do is offer it to you as an alternative way to resolve whatever controversy exists. And if your lawyer advises you to do so, you can accept the offer. Indeed, arbitration can be faster and a more affordable way to resolve legal disputes because it relaxes the rules of procedure, the rules of evidence used by the trial courts. The discovery phase is typically the most expensive aspect of litigation, and the less stringent rules of many arbitration proceedings can streamline the discovery phase and otherwise help to reduce the litigation costs for both parties. The board received reports that many current owners believe that the mandatory arbitration provision is great because Pepperidge Farm will pay for the entire mandatory arbitration process, which is not true. You need to read the new contract provisions. You need to talk to your lawyer about them because the fact is, under the proposed new mandatory arbitration, Pepperidge Farm will pay a couple $100 to cover the filing fees for the arbitration proceedings to commence, but every current distributor is still on the hook to pay a couple $100 an hour for each and every attorney and paralegal that represents them in the proceedings against Pepperidge Farm. On that note, the board urges every current owner to get their attorney to give them an opinion about mandatory arbitration and ask, is it true that mandatory arbitration often is more complex and costly than litigation in trial courts, depending on the rules and the regulations governing the arbitration proceedings? As many of you may already know from recent POAA newsletters with links to various news outlets with articles discussing how big companies are ruining small businesses through mandatory arbitration provisions. Big fish eat little fish, and the devil's in the details. We'll introduce the third and final rule of small business for today in just a minute. But first, every current owner needs to understand mandatory arbitration means that you voluntarily abdicate your constitutional right to access the Article 3 court system, that you're voluntarily walking away from the U.S. judicial system in favor of these unduly complicated arbitration provisions, instead of, under the existing contract, voluntarily agreeing to arbitration when it makes sense to you and your attorney to resolve a controversy. And some of you are probably thinking, well, big deal. None of us can afford to litigate against Pepperidge Farm anyway. They've got the resources to buy the best legal minds and most talented advocates on the planet. Many of you may remember that Pepperidge Farm crushed the association in litigation by racking up our legal fees through a protracted discovery process and pretrial motions. And after we spent $750,000 with the Dady law firm, the court dismissed our case before it was even considered on the merits of the claims. So Pepperidge Farm escaped liability again without paying a single penny for its wrongdoing. And then they spent the next few years expanding their unfair policies and practices even further. So you're absolutely right. None of us can afford to litigate against Pepperidge Farm on our own. And Pepperidge Farm is banking on that fact. But now it's offering to pay a few pennies on the dollar to settle wage-related claims because the U.S. judicial system certified the complaints as class. Hallelujah. But the cases really only scratched the surface of Pepperidge Farm's predatory practices. Our only prayer to stop the continuing unfair policies and practices of Pepperidge Farm is through another class action, like the Employment Misclassification class actions that got us to this point in the first place. But the new contract, which isn't disclosed in the motion and memorandum here, also prohibits you from even participating in another class action ever again. Is that good enough? The board doesn't think so. The board understands that some current owners trust Pepperidge Farm completely, implicitly, without question, and that some current owners trust Pepperidge Farm will not abuse its new right to allocate any product it wishes in any amounts it wishes whenever it wants, because they have the new right to object, and that they trust Pepperidge Farm will consider objections to the proposed allocations in a commercially reasonable way. And some current owners trust that the mandatory arbitration really is better for them than voluntarily agreeing to arbitration under the existing contracts. And in response, the board wants to introduce the third rule of small business. It's printed right on our money, and we're in business to make money. In God we trust, all others need to be verified. Many current owners, just like many small business owners, will give their trust based on their feelings, instinct. They go by their gut. And that's not to say that your instinct shouldn't be a factor to take into consideration. But how do you trust? Why do you trust Pepperidge Farm will even pay consignment sales commissions under the proposed new contract? There's no provision in the new contract about how you're going to get paid. What's more important to a consignee than how consignment sales commissions are calculated? Why did the parties make it such a priority to have express clarification that Pepperidge Farm recommendations are not contractual obligations, and that a current distributor can seek financial relief when there are problems through no fault of their own? But the parties didn't think it was a priority to expand or clarify the definition of bulletin prices, which historically were the wholesale prices in the industry standard bulletin price list that Pepperidge Farm stopped publishing for the bakery division in 2012, and they stopped publishing for the snacks division in 2015, in connection with a scheme to have trade promotions without trade spend. What does that mean? Doesn't mean anything. You can't have a trade promotion without trade spend, and the reality is that the trade spend budget is being subsidized by skimming commissions from distributors because Pepperidge Farm is manipulating the wholesale prices on the invoices and paying off of invoice instead of the price bulletin lists. Parties and their lawyers knew or should have known. There's no provision in the consignment contracts that's more important to current consignees, current owners, than how their consignment sales commissions are calculated. Yet it's not part of the characterization that was presented to the court in the unopposed motion, and it's not addressed in any way, shape, or form in the proposed new contract. Please, we urge you to read the proposed new contract, talk to your lawyer about it, and determine for yourself whether it makes sense to be automatically bound to the proposed new form of contractual relationship with Pepperidge Farm when the proposed terms and conditions don't provide any clarity about how you as a consignee will be able to earn consignment sales commissions, or whether it makes more sense for you to advise the court that you do not object to the nuisance value payments in exchange for releases of the wage-related claims, the context of the proposed class settlement, but you object to the proposed new form of contractual relationship with Pepperidge Farm because it doesn't really provide you with better protections from their unfair policies and practices. Pepperidge Farm Owners Association of America's legal committee determined that the proposed monetary relief is fair, reasonable, and adequate for the specific releases of wage-related claims. But it's not fair, reasonable, and adequate to effectively terminate the existing contracts, to mandate a radically new form of contractual relationship with Pepperidge Farm automatically. The board ultimately hired Fox Rothschild to help current distributors object to the proposed class settlement because the material changes to the existing contracts are so numerous and substantial that the terms and conditions of the proposed non-economic relief in the class settlement are tantamount to a termination of our existing contracts without cause. Pepperidge Farm is effectively buying back our existing businesses for the nuisance value payment of the wage-related claims and automatically replacing our businesses with the new revised form of contractual relationship that will supposedly better protect us from Pepperidge Farm's predatory practices, but as we discussed, will actually enable them to expand their initiatives to take back margins from current distributors. Every version of the existing consignment contracts with Pepperidge Farm take into account this exact scenario. Every version of the consignment contracts includes a termination without cause provision that requires Pepperidge Farm to pay the consignee fair market value of the franchise or the distributorship plus 25% of that value. What is good enough is the amount of money, the nuisance value payment that Pepperidge Farm is offering to pay class members to settle the wage-related claims. Also good enough to cover greater than or equal to 125% of the fair market value of your business. Only you can answer that question for your business.